So in my last video, the tone of the comments kind of had this vibe, like questioning whether or not the GOA is still relevant. So I'm just going to answer that question directly. Is the GOA still relevant? The answer is yes. Even after they get the Supreme Court to be like, hey, either the NFA and all gun laws are unconstitutional, there is no historical text at all that supports them, they all need to go away, or gun laws are unconstitutional and you can only be charged with a gun crime if there's another crime attached to it. You can't be charged with a gun crime all by itself. Regardless how they finally get the Supreme Court to say it, they will still be relevant because there will always be somebody trying to climb the ladder and snatch away power. There will always be a congressman that will throw out a bill that says, ban all firearms. It's just the way it is. It's human nature. It's been that way since the day of the cavemen. First guy came out of the cave with a club and hit his neighbor in the head and said, you can't have a club and you're going to get me food. It's been that way since the beginning of time. There will always be somebody. So yes, the GOA will always be relevant. Now I get why they're saying that, because they already got the Bruin decision. And with the Bruin decision, essentially, gun laws aren't constitutional. However, there are a handful of federal judges that are still clinging on to dangerous and unusual. If you're not familiar with what that is, essentially in the Heller decision, Justice Scalia had to justify the NFA still staying in place because he was brought up and indoctrinated that if there wasn't gun laws, people would just be running around the street all willy-nilly, like just shooting off firearms in the air and committing crimes left and right. And it would be exponentially worse if he said that the NFA was unconstitutional. So he had to justify the NFA. So he went back through history and he found a law called an affray. It's English common law. It was in Blackstone. Blah, 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 blah. It's been there before, during, and after the Second Amendment was written. So that essentially makes it a part of the Second Amendment. And what is an affray, you may ask? Affray is brandishing a weapon in a manner that terrifies the public. Now that's not verbatim. Like, you can read it yourself and look up the actual, like, how an affray is written. But that's the gist of it. So, during the law of affray, this way, people wouldn't be prosecuted for an affray without it actually being an affray, they had stipulations. One of those stipulations were, it had to be dangerous and unusual. Now, what they mean by that is you can't charge a police officer with an affray just because you're terrified he has a pistol, because it is usual for him to have it there. Okay? Now, you can't charge a kid with an affray because he has a squirt gun, because it is not dangerous. So the weapon needs to have some sort of danger, and it needs to be unusual for you to have it. And then you need to be brandishing it in a way that terrifies people. Now, if you actually use the weapon itself, that's a whole nother crime. So you haven't used the weapon yet, but you've done it in a manner that threatens people in an unusual way. And like, the whole point of the unusual is, again, you can't charge a baseball player with an affray for having a baseball bat. Now, even though they have baseball bats, let's pretend I took this paddle out on the field, and I was like, Empire, he was safe, I'm going to paddle your ass. But I don't actually paddle his ass. I just threaten him with it, and I terrify the public. I break the peace, basically. That would be an affray. So Scalia took that single sentence, dangerous and unusual, deleted the whole rest of the law, took dangerous and unusual, and said, boom, there's the history and context. The NFA is just. It is not unconstitutional. If you have a dangerous and unusual weapon, remember, he said if you have a dangerous and unusual weapon, well, obviously it can be regulated because this law has been around before, during, and after the Second Amendment was written. But that's not what it's about. Like, for example, somebody was charged with an affray for riding a horse through a courtroom. So basically, an affray has nothing to do with any individual type of weapon. It is how that weapon is brandished. Well, anyway, a whole bunch of judges are still clinging on to dangerous and unusual. Like, that's their lifeline. They're holding on to that. They got their teeth wrapped around it. They won't let it go. So we at least need the federal courts to get up to speed with the Bruin. So how does that happen? You have to take on criminal cases and make sure that there's a good lawyer there that can argue that in each individual courthouse across the country to each individual district, because first, we got the Supreme Court, they're on board with Bruen. Obviously, they made it. Well, now you have to get the appeals court to be on board with it. And this is where the experiment with the fundraiser comes in, which is right here, the Second Amendment war chest. Now, this is amazing. You want to know why? And this is where I'm assuming people thought that I was trying to say the GOA wasn't irrelevant, is because this is the legal fund. This goes directly to the lawyers. Say, for example, I donate $100 to the GOA. Well, the members of the GOA, they're going to take their payroll out of that. Then they got to pay for the building they're in. That's got to come out of it. And then finally, when they decide what case they want to attack, then finally, some of that money would go towards a lawyer. Where it's in a legal trust, they are legally obligated to only use this money for legal cases. If they went and spent it on a brand new yacht, we could sue them. Plus, it says right in the donation page what they're going to be using it for, and that is criminal cases. The GOA can't take on criminal cases. I explained it in the video, like think of a net, a drag net going through the ocean. When you're suing the government, that would be a big-ass shark. You need a huge net with huge gaps to be able to grab the shark and pull it through. Unfortunately, all the criminal cases, aka the minnows, just go right through the net. The GOA doesn't do criminal cases. I mean, they can, and once in a while they'll pick up like a niche criminal case, but if they started up picking up criminal cases, they'd go broke. That's not what they're there for. The GOA is for civil suits against the government. That's what they do. That's what they do very well, and they do it excellently. However, all these minnows are going through the net. For example, only 1% or 320 federal cases actually go to trial because most people plea out. They can't get a lawyer. They can't afford one, so they'll call up like the GOA or the NRA and be like, help, help, I need help. The GOA can't take their case. That's not what they do. If they started taking those cases, they would go broke and they wouldn't be able to go after like the Bruen decision, stuff like that. So this particular fundraiser is a small net. The idea is to catch criminal cases and start taking those to court to train these federal judges on exactly how they're supposed to rule in this type of case. So what would need to happen is a law enforcement officer would arrest the person, then the district attorney would charge the person, then the federal judge would sentence them, saying they got convicted. Well, now it would go to appeals court, and the appeals court would say, no, it's guilty, and then it would go up to the Supreme Court. The Supreme Court would be like, no, the Bruen decision, reconsider. So then it goes back down to the appeals court, and they have to reconsider. Basically means they find that particular person innocent. So then that appeals court instructs all their judges, hey, on this type of case, because of the Bruen decision, you cannot find these people guilty. You need to dismiss them. So then they instruct their federal judges to dismiss them. So then the DA would come up with the next charge, go to the federal judge, and the federal judge would be like, no, I've been instructed to dismiss these. So then the DA would stop taking these cases from the law enforcement officer. The law enforcement officer would slide the paperwork across the desk. The DA would look at it, and they would tell the LEOs that, hey, we are not prosecuting these anymore. And that is the only way to do it. And it's got to go district, by federal judge, by federal judge, by federal judge. They all have to be taught a lesson in order to get back on, at least up to speed with the Bruen decision. And again, that's what this fundraiser is for. This is so they can go after particular criminal cases. They're obviously going to have to be selective. It's going to have to be a gun case by itself. This way it can't be argued that, oh no, this case is being dropped because when the cops showed up, they forgot to read them his rights or something like that. It's got to be like, or the cocaine he had, they didn't test it properly, and that's why the case gets dropped. It's got to be specifically about a gun. Nothing else. Just a firearm charge by itself, like you bring a 17-inch shotgun into the gun shop because you think that it's supposed to be 16 inches. The gun shop calls the ATF. The ATF comes arrest you. That's where they would swoop in. They'd be like, no, it doesn't matter if it's 17 inches. That's unconstitutional. If you go back to 1776, which the Bruen decision instructed you to do, there's no history, text, or tradition saying that shotguns have to be a certain length. As a matter of fact, it's the exact opposite. They had short pistols. Like, that is okay. Then obviously it would get argued in front of the federal judge. That lawyer would explain to the judge what's going on, and the judge should throw it out. Should they not throw it out, then it would go to trial. They'd explain it to the jury. Say they get convicted, well, then it would go to appeals court. Hopefully that particular appeals court would already understand the Bruen decision and dismiss it right then and there. But if they don't, then obviously it has to go to the Supreme Court, then back down to the appeals court, then to the federal court. Like I said, the whole thing is a process. The judicial system needs to be retrained because they've all been indoctrinated in from the 80s and the 60s with their parents, the news, and everyone else telling them that you have to be hard on gun crime because that is the only way to clean up the streets. But there's no crime you can commit with a gun that doesn't already have another crime attached to it. Even if it's a stolen gun, well, there's theft. If it's a murder, well, yeah, it happened with a gun, but it's murder. There's already charges there. There's no reason whatsoever to have any gun crimes on the book. And the Second Amendment is very clear about this. Remember, the Second Amendment comes from the people to the government telling them what laws they're allowed to make. Not from the government to the people telling them what guns they're allowed to have. So what laws can they make? Shall not be infringed. It's pretty self-explanatory. 0 gun laws. We've given the government 0 power to make any gun laws. But, you know, things happened in our past. Our parents and our grandparents dropped the ball. They should have fixed this years ago, but they failed. And it is now our torch to carry, and it is our turn to fix this. So, please support the Second Amendment war chest. That's the only way we're going to at least get the federal judges up to at least the speed of the Bruen decision. Is let them fail. Let the appeals court tell them, hey, what are you doing? You can't charge him with this. The Supreme Court was very clear in the Bruen decision. There is no text, history, and tradition that supports his particular gun crime. And if that appeals court fails to do that, the district court, well then the Supreme Court needs to explain to the district court exactly what's going on. Then the district court needs to explain to the federal judges, and the federal judges need to explain to the DAs, and the DAs need to explain to the law enforcement officers. That's how it happens. Shit just rolls downhill. Right now it's still at the top of the hill. We need it to start rolling down. This process takes years, so be patient. I mean, just going through a simple litigation, like you're looking at like 1 to 2 years just to get it up to the point to be in front of the federal judge where they have the power to make the decision to say, no, that is unconstitutional. Now, if they get found guilty, well, now you're looking at like, what, another year, 6 months, somewhere in there before it gets to appeals court, and then you got another year, maybe 2 years before the appeals court makes a decision. And if they've dropped the ball and messed it up, then you got more years to get up to Supreme Court. Again, this all takes time. We will get there. So be patient. But yes, the GOA will always be relevant. Anyway, if you'd like to help support me directly, the best way to do that is purchase a Freedom Star, which has not 1, but 2 Scar 17S's, the best battle rifle ever made, on a single patch with a Velcro backing that you can use to stick directly to your tactical gear. Or, if you're not comfortable purchasing a patch from ShopOnlyTechFans.com, you can always shop at my Amazon store. The affiliate links are in the description down below. Just by clicking on those particular links, even if you don't purchase what that particular link is for, just clicking on it, doing the Amazon shopping you were already going to do anyway. I had a little kickback for it because you came there off my channel. Thank you for watching. Don't forget to subscribe.